So Sajid, I'm starting.
Yes, please.
A very good afternoon to all the esteemed panelists and dear participants. I, Chirag Balyan, on behalf of Center for Arbitration and Research, Maharashtra National Law University, Mumbai, welcomes you all to witness the Oxford-style debate on third-party funding of dispute resolution. Is India ready today? Today is the era of both information and misinformation. Truth and lies are just one click away from us. It is a challenging task to separate grain from the chaff. Therefore, it is important how we interact, communicate, and spread information. It is for this reason we chose a dialectic method to discuss the topic of third-party funding of dispute resolution. It is important to engage with such issues from the multiple viewpoints. Therefore, we have a diverse panel, including a corporate, third-party funder, quantum expert, arbitral institute, law firm, advocate, arbitrator, and myself as an academician. India is a huge disputes market and has tremendous potential for litigation funding as an asset class. Developed countries like Australia, Canada, Netherlands has already successfully embraced third-party funding. However, a survey conducted by Bloomberg in 2018 indicates that 70% of Indians feel that it is not legal. Is this a correct perception? Our experts will discuss that. There are at least 2 Supreme Court judgments which says it is legal. There are a couple of state amendments in the Code of Civil Procedure as well. But then why the question arises that India is ready or not? Maybe there is something more than law which discourages funders to invest in India. Is it delay? Is it enforcement? Or is it something else? Our experts will also discuss some of the perspective on these issues. It is also argued that third-party funding will result in access to justice. How true is that? Only time will tell. But for today, we have Ms. Seok, who will moderate this session. She is the CEO of Singapore International Arbitration Center. She is qualified to practice in both Singapore and England and Wales. She is also admitted as a solicitor in England and Wales and Hong Kong. Her wide array of past experience as a practitioner, a general counsel, and now as a head of SIAC makes her a perfect moderator to handle this diverse panel comprising of eminent experts. Before I pass on to Seok, couple of housekeeping rules. Topics of the debate will be available in the host speaker window as the profile picture. Audience can ask questions in the question and answer tab only. Panelists are requested to keep themselves on mute if they are not speaking. For audience, you may note that if there is a difficulty in joining the Zoom session, we are also live on our YouTube and Facebook channel. You can tune on that. Over to you, Seok.
Thank you, Chirag, for the introduction. Good afternoon, everyone. I'd like to thank MNLU for inviting me to moderate what promises to be a thrilling debate. Thank you to our jury, debaters, special guest speakers, and especially you, our audience, for spending Saturday afternoon with us. We have over 700 viewers from India and all over the world today. India is very important to SIAC, and I'm greatly honored to be a part of this with our dear friends and users. As we know, with an increase in cross-border transactions, international commercial arbitrations, and investment arbitrations have increased. A key benefit of third-party funding is access to justice. It helps financially weaker claimants to successfully pursue their legitimate interests without putting their businesses at economic risk. As Chirag has mentioned, third-party arbitration funding is now permitted in jurisdictions such as Australia, the UK and Europe, and the United States. Singapore has followed suit in 2017 and Hong Kong in 2019. At the institutional level, we are often asked, what role should an arbitral institution like SIAC play in regulating third-party funding? As an arbitral institution, our mandate is to ensure the integrity of the arbitral process. Arbitral institutions should therefore require disclosure of the existence of funding and the identity of the funder to avoid actual or perceived conflicts of interests involving arbitral tribunals. To this end, SIAC published a practice note empowering arbitral tribunals to require such matters to be disclosed, as well as details of the funder's interest in the outcome of the case. The SIAC investment arbitration rules also contain similar provisions. And so after that short commercial break, let us turn to India. India has not yet actively recognized third-party funding of arbitration in its legislation. Given that India is a potentially huge market for funding arbitration disputes, it is timely to have a debate on this very topic. I'm sure all of us are looking forward to this no-holds-barred debate that is going to take place shortly between the two debaters on the motion, third-party funding of dispute resolution. Is India ready today? It gives me great pleasure to introduce the grand jury, our debaters, the representative from a corporate seeking funding, and the independent quantum expert appointed by the grand jury. The jury includes some very well-known names who actually need no introduction, but I will introduce them anyway. We have Ms. Sherina Petit, Head of International Arbitration, EMEA, Head of India Practice Global at Norton Fulbright in London. Ms. Shaneen Parikh, Senior Equity Partner at Cyril Amachan Mangaldas, Mumbai, and also a member of the SIAC Court of Arbitration. And we have Mr. Dian Chinappa, Senior Advocate and Additional Advocate General for the state of Karnataka. For the motion, we have Fereshte Sethna, Founding and Managing Partner of DMD Advocates, Mumbai. And against the motion, we have Mr. Dilip Massand, co-founder and CEO at Phoenix Advisors in the UAE. The corporate seeking funding is represented by Mr. Bhaskar Chandran, General Counsel and Legal Head for the GMR Group, Delhi. The independent quantum expert appointed by the grand jury is Mr. Mrinal Jain, Managing Director at FTI Consulting in Mumbai. And we owe Mrinal a lot of thanks for really putting this together, including my the running order. Thank you so much. Before we proceed further, we would like to conduct a pre-debate audience poll on the question, is India ready for third-party funding? Yes or no? Can we please have the poll up on the screen? The audience will now get 30 seconds to respond to the question, starting now. All right, that's 30 seconds. Could we see the results on the screen, please? So 64% voted yes and 36% no. It'd be quite exciting to see how that changes at the close of the debate. Now, to set the stage for the debate, I would like to invite Bhaskar now to share his views from the perspective of a corporate seeking funding. We have a total of 10 minutes for this, Bhaskar, and 6 questions. So starting with the first one, are corporates open to considering third-party funding of their disputes in India?
Thank you, Seok. Thank you, Seok. And really excited to be part of this webinar and this session. And Seok, before I go and then give my answer, I would like to really thank Maharashtra Law University, SIAC, and FTI Consulting, and in particular Mrinal for putting this through. Mrinal, you have been outstanding in terms of getting these topics together and getting this Oxford-style debate. And hats off to you for doing that. And to set the context in place, Seok, I guess the first question is with respect to corporates open to third-party funding in TPF in India. To me, I think the answer is a clear yes. The answer is a clear yes because one, the litigation cost in India, they are frightfully expensive in the first place. And any litigation as such is like a business proposal for me. So when I'm sitting as a general counsel of this large group and I have a budget and I need to be very clear that where I'm going to put my money, I'm going to put it in this litigation, put it here, or I need a very clear budgeting plan, as I move forward. The cash flow is a real constraint, and therefore the lack of funding to take care of the genuine claims that I have, I see TPF as a perfect solution to this. When I say TPF as a perfect solution, more so in the current context, because today we are in a pandemic situation where the businesses are not doing well, all the more difficult in terms of cash stretch and cash constraints that we have. I have pending litigations that I need to take it forward. So even in the current context where there is a pandemic, I think the answer is that TPF is a perfect solution. But having said this, is availability of cash or availability of funding, is that the only question? To me, it's one of the many questions, and there are other factors to be considered as well. To me, the structure, terms, regulatory issues are the other aspects that one would need to look into. But having said that, a definite perfect solution in my view and the clear way forward would be corporate seeking fund. TPF is a good solution.
Thank you, Bhaskar. Please provide a perspective on where we are and what is required for TPF to be successful in India from the point of view of a corporate. Do you think TPF could be implemented in India merely by interpretation of the existing position of law by the courts?
I guess that as a corporate and as a general counsel, we have a dilemma. And to me, I think the answer is a clear no. And Chirag sort of alluded to this in terms of the Supreme Court judgments earlier, in his introduction. And the evolving concept of a TPF, in my view, just cannot be implemented merely by interpreting the existing legal certain judgments at this point of time. As on date in India, there are no clear law, either barring the TPF or allowing the TPF or regulating the TPF. In addition to what Chirag talked about, I think there are some states in India, they have also amended their civil procedure code. CPC has been amended, I guess, in Maharashtra, Gujarat, and a couple of other states. While these are all the positive steps, my view is that there could be two scenarios for a TPF to be successful in any jurisdiction. One model could be a self-regulation model, like what you have in France. There is a self-regulation model, then it gets regulated as per the self-regulation model. Other is a clear regulatory approach. I personally feel that a legislative acknowledgement in India is far better in India, and that's something that is the need of the day. When you have a regulation, you will have the uncertainties, you will have that part of the regulation getting cleared, interference of funders, confidentiality, the transparency, conflict of interest issues, all those things. So once a regulatory legislative changes are brought about very carefully in India, I feel that TPF will successfully take off, not in the current scenario, but only when a scenario where you have a regulation in place.
Do you agree that the lack of transparency in the arbitration proceedings, the enforcement of awards, and actual recovery of monies are some of the key challenges to implementing TPF in India?
Absolutely, absolutely. Like for example, when corporates, I just talked about the corporates having the regulatory certainty. I guess the funders would have the same issues as well. In fact, funders would need it more than the corporates at this point of time. And when there is a jurisdiction where where the these issues are not very certain, and when an enforcement of award becomes a challenge in a particular jurisdiction, you have public policy issues as a defense in those jurisdictions. It would be very difficult for a funder to take a view. For him, the answer is not the successful claim. It is a successful recovery of the claim, which is paramount for the funder to take a decision. So I may have a very good case. I may have a case where legally I'm sound, I've got good merits, and I would get an award in my favor as well. But if I'm not able to enforce that award in that jurisdiction, and there are issues in that jurisdiction, then the funder would be very reluctant to look at it, in my view. And therefore, having regulatory clarity, enforcement, in my view, becomes of paramount importance for a funder to take a view.
India does not allow lawyers to work on a success fee or a modified fee basis. Do you think this is likely to result in a misalignment of interest between the corporate, the funder, and the Indian Counsel?
I think yes, but when I looked at this, when I was looking at this particular issue, I had a different thought as well. And the success fee not being permissible in India is definitely a misalignment, in my view. The lawyers in India are not you cannot have a success fee based model with the lawyers. But the key question, and that's something to think about more from a corporate standpoint, is that if a success fee model is allowed, then do I need a TPF in the first place? Because I have already had a success fee model with my lawyer, then do I need funding in the first place? Would be an additional question, right? But be that as it may, the answer is that is it misalignment? To me, I think a success fee model not being permissible is definitely a misalignment with the for TPF to take off in India.
What is the level of preparation and the evidence required by a corporate during the due diligence phase to assist funders in their evaluation?
To me, I look at it as like any other business proposal. You have a business model, you take it to the lenders, and then you go through with the diligence. Very similar to that. And you have a proposal, you have a good litigation, and you feel that your claims are, you will be successful in your claims. And here, instead of a PE investor or a banker or a lender, you go before a TPF funder, and then you present your case before him. I guess that you have to have, to me, I think, a good case coupled with the regulatory things that we talked about. But I guess that it's something like a project appraisal, and something like a diligence has to be, it will be a full-fledged diligence. The funders, in my view, will get into the details of not only the merits of the case. I think the funder will get into the details of, do you have the right counsel being part of this? Do you have the right factors have you taken into consideration? And you have your professional approach to this entire aspect, and so on and so forth. To me, I think in addition to all these things, like from my perspective, the case on the good case on merits, the good counsel being part of this, they may even ask for a legal opinion to support what I am saying, and so on and so forth. Equally important, in my view, is that the funders would also look at whether the respondent who is capable of making payments. So it's not the question of I have a good case and I'm able to get a good award at the end of the day. Whether the award the respondent is as the financial muscle to pay this money at that point of time. So equally important is for me, in addition to all the merits from my perspective, I need to also convince the lender, convince the TPF, the funder, that even the respondent we will be able to recover the money at that point of time from him. So it's a full project space that one needs to go into, and it's not something very easy that, okay, fine, funds are available, you just go, and then, you know, it's like a full diligence that one needs to go through with.
All right, we've actually gone just past 10 minutes, but just very quickly, in 1 minute, could you give us your views on portfolio funding? In particular, because as we understand, you are a respondent in several matters, and such cases would not otherwise be, could not otherwise be funded by funders on a standalone basis.
Just in 1 minute and in one example, and so when you are a respondent and when you are seeking a funding, it's like a freebie, because you have a portfolio of cases as a claimant, and then you add on to this in your this. So when you buy a toothpaste, you get a toothbrush free, and is the toothbrush is at zero cost, or this fund is already added back to the toothpaste cost? So that's a key question that I will have to go through. And I guess that in addition to that, there are also conflicting issues and things like this. So there are two triggers that I would look at: whether I am paying the real cost, or is it something added on somewhere else for me? And so that's one thing I will go into. The second aspect is that, does it create additional conflict issues for me? So it depends on case-to-case basis, and it's not a very clear answer, yes or no. Depends on case to case. Just in summary, I just want to say this. One is that to me, I think TPF is a perfect solution to corporates. Corporates will be looking at TPF provided you have a transparent regulatory model, and more importantly, reasonable commercial terms. So these two are the two things, as a general counsel and a general counsel of a big corporate like a JMR group, we will be looking at it. And I'm SIAC, I'm eager to hear the debate from both of them as much as the audience. And good luck to Fereshte and Dilip. And we hope for a great debate going forward. Thanks for the opportunity.
Thanks very much, Bhaskar, for your excellent insights. So without further ado, I would now like to commence the debate. The format is going to be as follows. We are going to have each speaker speak for 10 minutes on the following topics. Topic 1, the law on third-party funding remains a question mark in India, and we need to evaluate whether TPF could be implemented in India merely by interpretation of the existing position of law by the courts. The second topic is the enforcement of awards and actual recovery of monies is a key challenge in India. Topic number 3, more than actual recovery, it is the time delays which is a bigger challenge in India. Topic 4, in most cases in India, the wasted costs claim is not enough to meet the 1:10 ratio, and funders reject cases where the realistic claim value is primarily determined by loss of profits claims on account of uncertainty. Topic number 5, India does not allow lawyers to work on a success fee or modified fee basis, which is likely to result in a misalignment of interest between the claimant, the funder, and the Indian counsel. And the final topic, number 6, there are tax, regulatory, and structuring challenges to doing business in India, and this acts as an entry barrier. After each of the speakers has presented their views on the topics, we will have each speaker present their rebuttal arguments for 5 minutes each. I would now like to invite Fereshte to speak for the motion to start the debate.
Ma'am, please unmute yourself.
Fereshte, you'll have to unmute.
Yeah. Greetings, everyone. Before I address the motion, I place on record my appreciation to everyone who is participating today. Thank you, Seok. Thank you, Chirag and team at MNLU. Thank you, members of jury, Sherina, Shaneen, and Dian. A big thanks to my worthy opponent, Dilip, for effectively stacking this one up against us. And of course, to Bhaskar for his views on corporate seeking funding, which were very interesting. And finally, and not the least, my extreme level of appreciation to Mrinal, who has painstakingly calibrated everything that you see here today in terms of ensuring that we have, hopefully, the level of perfection that we will in this debate. So thank you, everybody. Thank you, members of audience, for sharing with us Saturday afternoon to debate this issue. With that, let me begin. Let me start by perhaps giving us a flavor of what third-party funding is in the realm of the international space, because quite clearly that will lend some perspective to what is it that I will place on India. In July 2017, a $320 million award was published by an ICSID tribunal comprised of Judge Thomas Bergenthal, Henry Alvarez, and Dr. Kamal Hussain in an investment treaty arbitration case of Teinver versus Argentina. The finding was an expropriation and breach of standard of fair and equitable treatment. Among the myriad issues that fell for consideration over the course of that arbitration was third-party funding. This was an arrangement that was entered into by Teinver with Burford Capital. I'm sure all of us on this debate here today know Burford Capital is a leading third-party funder. This arrangement was entered into back in 2010. It was arranged on the anvil of a bankruptcy proceedings of Teinver, and the bankruptcy re-administration effectively permitted for the arrangement to remain intact. One of the issues that fell for consideration by the tribunal, the arbitral tribunal, was as to whether or not Spanish bankruptcy law would have an override over Spanish civil law. The arrangements that were entered into by Burford came under scrutiny. Those arrangements, for those not entirely familiar with the kind of structures that one finds within third-party funding, were 40% of the first $100 million that may be awarded to the third-party funder. 30% of net recovery between 100 and 500 million. 25% of net recovery between 500 and 800 million. 15% of net recovery above 800 million. This was a typical TPF arrangement as we know it. Criticisms against third-party funding would inevitably stand obliterated on appreciation of the fact matrix in Teinver, where there was clear justification for third-party funding in circumstances where Teinver was forced into bankruptcy and therefore rendered, for all intents and purposes, unable to access justice. States who act in violation of internationally recognized investment treaty rights, despite rights liable to be enshrined by capital importing countries, must recognize that third-party funding in those circumstances is liable to be availed by a party who has been caused prejudice on account of the acts of that state. Multiple other justifications prevail for TPF. There was, of course, the 2012 July award in Casar de Valores versus Russian Federation, conducted under the aegis of the Stockholm Chamber of Commerce, where again, that award accorded recognition to Group Mentap's funding efforts by virtue of it being a former shareholder of UCOS, in order strictly to create a favorable precedent in the context of energy treaty with Russia. Now, clearly that, in my respectful submission, members of audience, is justification enough for third-party funding to find immediate acceptance. And as Bhaskar already told us, that resonates perfectly well with corporates as well. Coming therefore to deconstructing third-party funding, shorn of these sophisticated hybrid evolutions that one finds, there are myriad genres in which one finds third-party funding. The atypical Burford litigation finance arrangement in Teinver is atypical non-recourse type of funding. You then have loan funding. You have liability insurances, which we're also familiar with. That ranges from D&O to shipping mutual, P&I, defense club related fundings, which are typically a combination of before and after the event insurances. You have equity financing, which may involve acquiring equity in a claimant and deriving return from distributable profits of a particular litigation. Outright sale of claim or assignment of claim, including by liquidators, that is typically a similar fact circumstance with TINVA, as you would just have heard. Cause-based NGO support, including nonprofits who run public interest litigation. Sale or assignment of awards, which brings within its sweep a subgenre of enforcement financing. You then have refinancing options. You have law firm financing options. And of course, finally, you have what is frowned upon in India, which is the contingency fee arrangements with law firms. Is that reason to doubt then that India is not ready for third-party funding? Is contingency fee arrangements being proscribed the sole reason why third-party funding should be treated as not readily available for acceptance in India? The fact is that, firstly, there is no legislative denouncement of such types of funding. Our arbitration framework is formulated, as we know, on the Untitled Model Law. It was legislatively ushered in through the 1996 enactment. And we do not, 24 years down, have any iota of restriction that is imposed through that legislative mechanism on third-party funding. With the 1996 Act, Indian law has made a giant stride into the international world of arbitration, with legislative intent quickly paving the way for interpretation in the Supreme Court judgment in the case of Bhatia versus Bulk, since of course set aside, supporting the grant of interim relief by a court in India for arbitration seated in Paris. This is a matter I had privileged to handle right from district court up, and Supreme Court reversed findings of multiple high courts in coming to its conclusion, which eventually came up for consideration only in Balco almost 10 years down. Several amendments to the 1996 framework followed, each bolstering the right of parties who seek arbitration as a means of dispute resolution to be preserved. Not least for the reasons that third-party funding has, in 2017, been recommended by the high-level committee that examined institutionalization of arbitration in India. Is third-party funding entirely liable to be accepted by our Indian courts? It is in fact apparent that the Indian legislature, having been cognizant of the recommendation of 2017, has rightly elected to leave this matter within the realm of the regulatory framework of arbitral institutions. We see internationally that institutions that have led the way on third-party funding, including the SIAC on investment arbitration rules, including the IBA guidelines, including the London Association of Litigation Funders Code of Conduct. All of these are inevitably association-driven regulatory frameworks that come in as checks and balances to ensure that arbitrators who may have potential conflicts of interest with a third-party funder should effectively be entitled to have knowledge of and make appropriate disclosures, obviously in the interests of, as Seok mentioned, preserving the integrity of the arbitration. Absent legislative or regulatory restrictions, therefore, in relation to an Indian citizen or corporate, another alternative that remains available, no doubt, to the Indian seeking an arbitration dispute resolution mechanism is, of course, the choice of seat in relation to arbitration in manner that facilitates access to expeditious outcomes, inherent whereto is access to third-party funding. Guidance.
30 seconds, sorry, I'm sorry.
Keeping abreast of international developments and recognition for enforcement of foreign awards remains the hallmark of a multitude of judgments in Indian courts. A recent May 2020 judgment delivered in the case of Spentex Industries by the Delhi High Court, which pertained to an anti-arbitration injunction suit, specifically recognized that a contingency fee arrangement that was entered into between a law firm, a US-based law firm, and Spentex should not effectively be interdicted by an Indian court. In fact, it recognized that such an award, when made, would be entitled to express recognition under the New York Convention Awards regime under Section 45. You all know about the Supreme Court judgment in Balaji, which effectively recognizes third-party funding. It also recognizes that contingency funding in India, contingency fees in India is effectively out of sync. I agree with Bhaskar when he says misaligned. Must India legislate? I submit no. There's no need to wait for legislation. The delivery mechanism lies available through India's arbitral institutions. It's time they stood up to it and they must deliver on it. That, in my respectful submission, will ensure that India is and will remain ready for meeting all challenges in relation to third-party funding. Thank you, everybody.
Thank you, Fereshte. We're off to a great start. So now I would like to invite Dilip to speak against the motion.
Thank you so much, Seok. And firstly, let me thank all the participants here, all the panelists, the judges, my esteemed adversary, though I hesitate to use the word adversary, and everyone who is in attendance. I must tell you that this subject is quite challenging to address in 10 minutes, particularly having been someone who has watched developments in India for the last 10 years from our bird's eye view in Abu Dhabi. The question as we see it, is India ready for third-party funding today? I think it's a matter of perspective. If you are in India and you are on the ground and you are seeing these developments, you might say, yes, India is ready for third-party funding today. However, if you're in the funding industry and you've been keeping a keen eye on India, you would say tremendous progress has been made and we are at the last mile of the solution. And you'd be willing to roll up your sleeves and do the hard work and implement it as we are willing to. I think what we would like to see, and much of the funding community would like to see, is India follow Singapore. We would like to see practice notes, rules, draft regulations. We would like to see those distributed and inputs solicited from the Indian legal community and funders themselves. The fear is that if we rushed into third-party funding, or if foreign funders rushed into India today to fund disputes, we would have a scene similar to what the famous jurist and philosopher Jeremy Bentham described in the English courts before the rule against champerty and maintenance came into being, when he said, "A mischief in those times, it seems too common, was that a man would buy a claim in hopes that power might convert it into a strong one, and that the sword of a baron stalking into court with a rabble of retainers at his heels might strike terror into the eyes of a judge upon the bench." While certainly no one is going to strike terror into the Indian judiciary, the element of mischief and the openness for mischief remains. We can look at the existing body of law that's in the courts and we can ask ourselves, is it appropriate for third-party funding? From our position, no. It is a maze, the rules are fragmented, and they are difficult to navigate. We point to the Privy Council rulings that say champerty and maintenance do not apply in India, that third-party funding can be seen as access to justice. But these rulings date to 1876, 1878, and 1939. The Code of Civil Procedure, which is often cited as allowing third-party funding or recognizing it in 4 states because funders can be impleaded or held liable for costs, to me becomes problematic because I think it can result in forum shopping, where you can end up with claims being assigned to entities outside of those states where funders or anyone financing those are not necessarily going to be subject to adverse costs. And we see this in other jurisdictions, particularly the United States, where for years patent claims were moved to the Eastern District of Texas because juries are infamous in the Eastern District of Texas for being against large corporate interests. The Indian Contract Act, which provides several grounds for contracts to be set aside due to public policy, dates back to 1872. This is problematic to us because funders are reluctant to disclose the terms of the agreement. Therefore, if this act is raised, are we forced to now to disclose the terms of the agreement broadly? And even the Arbitration and Conciliation Act, which has galvanized everyone's interests on India, does not go far enough. As stated, a report was commissioned as I think as far back as 2017, which recognized the need for India to follow Hong Kong and Singapore to enact legislation, but that those recommendations were not included in the recent amendments. In terms of enforcement and actual recovery, I think we have to look at this from the prism of the 4 pillars of funding. The 4 pillars of funding are merits, jurisdiction, quantum, collectability. There's also a 5th one called time. In India, enforcement is quite challenging, as we know. As a matter of fact, India is ranked 163rd out of 198 by the World Bank for enforcement of contracts. In terms of arbitration proceedings, yes, they are required to be confidential. I think Section 42 of the Indian Arbitration Act states this. One of the issues is that funding agreements often require updates from counsel. And if we are requiring reporting as to the proceedings, have we now violated that rule of confidentiality? And are we putting counsel into a conflict? In terms of enforcement of the award, enforcement of the award is subject to the Indian Code of Civil Procedure. Under that Code of Civil Procedure, every attachment and sale of asset is subject to objections from individuals and entities which may have adverse claims on such assets. These claims may be made by anyone, starting from unpaid workers to secured, unsecured, or unsecured creditors to unrelated individuals claiming ownership rights. Every such claimant is entitled to object to such attachment or sale, and if his objections are rejected, then to travel right up to the Supreme Court to seek redress of his grievances. Therefore, every attempt to attach and sell an asset can potentially result in multiple litigations, each of which will be quite time-consuming, expensive, and subject to numerous levels of interim or final appeals. So mischief can be played in the enforcement. In terms of time delays, from our understanding, it can take up to 5 years to get a first decree in India. If appeal and execution, you would have to add more time. So let's say 7 to 8 years. Most funders are asset managers who have promised their investors a 5-year return on capital at maximum. Maybe they can extend another year or 2. There's a danger then as you go further out in time. And that's the type of investor that you will attract. It is usually only speculative funds that have the appetite for large, long, drawn out battles that are attracted to this kind of an investment. That is a different breed of investor than the third-party funders that we see, who in some jurisdictions are self-regulated and are willing to abide by regulations in other jurisdictions. This is a breed of funder that is more aggressive with the ability to pursue interim measures in several jurisdictions. They also have a propensity to use negative publicity against the counterparty. One such example is a case of Elliott versus Argentina, where you saw a hedge fund that literally put Argentina onto the verge of bankruptcy and fought that fight for a period of 10 years. Third-party funders are not, this kind of funder is not interested in a long-term presence. They are simply looking for big wins. Therein, the door is open for mischief by well-armed speculators and not disciplined third-party funders. We talked about, at some point, wasted cost claims in India. This brings us to quantum. If you look at it, the funding industry has a rule of a 1 to 10 ratio. We like to see budgets that are 1/10 of the claim amount. So for instance, if the budget is 1 million, we want to see the claim of $10 million. However, and I'm using dollars, sorry. However, if in that claim amount, lost profits of 50% or 5 million, funders will discount that. This will drop it out of the 1 to 10 ratio and make funding harder for the claimant to obtain. Success fees. India does not allow success fees or modified fees. Again, I think the rules that govern this are outdated and out of context with today's economic climate. They go back to the Privy Council, 1954, 2015, 2018. In 2020, we have a situation where we have a liquidity crisis globally and domestically. Corporates are hurting, banks are hurting, law firms are hurting. And by the way, Indian lawyers we find to be very expensive when we look across the globe. So we believe that just as corporates are being creative, Indian lawyers should be given the opportunity to to hold hands with the corporate and the funder, and we need an alignment of interest. This will also give more confidence to the funder, as sometimes it's often part of the diligence exercise. In addition, it enforces access to justice. For instance, in India, you have a new law where minority shareholders can bring actions against large corporates. How will they fund those cases unless lawyers are allowed to participate in that? It also, as we heard before, will free up balance sheets for the corporates so they can preserve jobs. And another mischief is that we are seeing Indian lawyers propose gray area workarounds this, where if we fund something and there's an SPV outside, they will take an interest in the SPV. And finally, let's look at the current tax, regulatory, and structural environment in India. If India was ready today, you would have a flourishing domestic third-party funding industry. You would not be looking at foreign funders to step in and asking them to navigate this environment. Under FEMA, we don't know if funding is a capital account or a current account. If it's a capital account with repatriation, then we are going to need RBI approval. And is our profit taxable? If it's a current account and it's a non-recourse loan, it's okay. But then loans are strictly governed by the RBI or at the state level in India. But third-party funding loans are not included in that. Again, we are seeing lawyers proposing creative ways to get around this, saying assign a beneficial interest to the funder outside of India. The interest is assignable only when it comes to fruition. This creativity is more mischief.
You have 10 seconds to wrap up.
Okay. Well, in the end, what we would like to see is a clear regulatory framework. Funders should have a minimum presence, minimum capitalization, disclose the source of funds, be approved to offer third-party funding, and let's even have a tax regime so that the government can make its share of our profit on issues in the domestic market.
Thank you, Dilip. Well, both our speakers have made some very persuasive arguments so far. Fereshte, are you ready for the rebuttal? You have 5 minutes starting now. Could you unmute, Fereshte? Thank you.
Yeah, okay, great. I was, I think, muted by the host, which is why I couldn't unmute from my machine here. All right. So let me start with the last point that Dilip made first. He said that there are tax, structuring, and regulatory challenges. I submit that anyone who looks at tax as anything other than a cost is clearly perhaps not aligned with the work that is going on globally in relation to ensuring that every dollar earned is taxed. With regard to regulatory, clearly there is a framework. I am not aligned with Dilip when he talks about various alternatives that are being thrown up and advised and which don't necessarily appear to make the mark in terms of available alternatives. We have seen certain alternatives, they work efficiently. And in particular, when it comes to an Indian corporate who is going to be in a position to avail of third-party funding in an arbitration which is seated such that permits for third-party funding, I see absolutely no scope for an Indian court to interfere or intervene. Coming then to the issue of enforceability, a critical one, no doubt. The fact is, if you have a successful award, you will be in a position to inevitably obtain some form of security for that award from a court in India because our act specifically allows for that. Now, whether or not your facts qualify for that security is, of course, a fact-specific issue, but the law exists. That law is capable of delivering up that enforceability related security within, and in my experience, no more than 2 to 8 weeks on certain cases where a judge considers it appropriate to grant that security. We have any number of precedents with regard to that, and I would think, therefore, that a concern in relation to enforceability is certainly not warranted and certainly one that is capable of being gotten over. Coming then to the timeline that you spoke of, Dilip, I have to tell you that I chose Tynever specifically to highlight that the Burford arrangement was dated 2010 and the award was made in 2017. That's in public domain. 7 years for that award. And you said 7 years in India. I would think, given that we have a significant amount of amendments in relation to timeframes that an arbitration will entail in India, again, that is an issue that has completely been addressed by the Indian legislature and therefore no longer should remain a reason for concern. It seems to me, in particular, that all of the issues, therefore, that appear to be hurdles for third-party funders appear to be dated issues, appear to be issues that require a fresh relook, and very clearly are matters that would perforce have to be tested in our courts in order for the results to become apparent. I would therefore think that to the extent that there is a perception by the funders that Singapore or the Hong Kong legislative mechanisms are the ones that should in fact be followed, I submit not at all. How is Australia doing? How is UK doing? How is Canada doing? How are all of those jurisdictions doing just fine without a regulatory framework? It is self-regulation. I heard Bhaskar say that he's in favor of regulation. No doubt, regulation brings in that added layer of certainty. But the question is, do you need certainty where the law does not issue a proscription? That, in my respectful submission, is the answer, and a clear answer to a third-party funder that is looking to India. I don't believe that the Privy Council rulings of 1800s or any of the civil procedure code related issues are really matters that would come in the way of third-party funding in relation to arbitration. In fact, they don't come in the way of third-party litigation in court. And as I explained, across 10 genres of third-party funding types of mechanisms, clearly most of them are in fact in force. I have enforced any number of shipping arbitration awards made in London, which effectively come with third-party funding because all of those awards are inevitably funded by the defense mechanism of the Protection and Indemnity Club. Those defense clubs effectively fund all of that litigation, which is a matter known to courts.
10 seconds. Sorry, Fereshte, if you could wrap up, please.
Sure. In effect, therefore, I'm of the view that third-party funding is already, in fact, in place, is here to stay, and I don't see any court interfering with it. And the Balaji judgment of 2018 Supreme Court has very clearly said third-party funding is recognized in India. Any misconceptions by the third-party funders should be cleared up immediately, I would think. And to the extent that they are not, they should test our courts will deliver. I'm confident of that. Thank you.
Thank you, Fereshte. And now, final words from you, Dilip, in rebuttal.
Thank you, Seok. Rather than issue a rebuttal on each of these specific points, I think the best evidence I have that India is not ready for third-party funding as we see the industry is that you do not have a flourishing domestic industry of third-party funders. What you have is a hybrid, you have a mosaic, you have stressed credit investors who are involved in this. You cited many participants, but you cited no existing third-party funder that is participating in funding in India. I think, again, when you look at those 4 pillars, on merits, absolutely, India checks the box. On jurisdiction, I think it's the perspective. If you're on the ground, if you are a vehicle that has a structure in India in place, then it meets it on jurisdiction. In terms of quantum, I think we will be hearing from a damages expert on quantum. Time, Fereshte cited a case which was Burford, which was 7 years to award, but we haven't yet looked at the enforcement of that. So I think the jury is still out to me in terms of time on that. What I will tell you though, is the approach that funders want to see, and which we are willing to spearhead, is one where all participants roll up their sleeves, work towards a draft set of regulations, where that is circulated, where the investment community says, yes, we are ready now, where we have legislative approval for this, just like other forms of foreign direct investment in India. And for me, this is very personal. My family in 1991 was the first American engineering company to set up offices in India. We actually bid on the Bandra-Worli Sea Link project in the early 90s. We left India in 1994. Today, I sit in a place in the United Arab Emirates where we have $15 billion of non-performing loans by Indian borrowers who are in India. We need to find a way to come to India to try to enforce on those non-performing loans. We sit in a place where $5 billion has come into the Indian private sector in the last few years, A, for distressed debt, B, for your telecom sector. We want to make this a productive form of foreign direct investment so that other forms of foreign direct investment won't feel prohibited from coming to India. And in terms of those other funders, I will make my pledge that if we have a working committee with MNLU, I myself will go to Burford, Harbor, Therium, and I will try to build consensus with those funders so that we can make this visible, transparent, and efficient.
Thank you, Dilip. I'm sure the audience will agree that it's been a fantastic debate and join me in thanking the speakers. I would now like to invite Mrinal to share his views on topic 4. And for the benefit of the viewers, topic 4 is, in most cases in India, the wasted cost claim is not enough to meet the 1:10 ratio, and the funders reject cases where the realistic claim value is primarily determined by the loss of future profits claim on account of uncertainty. As I had mentioned, Mrinal is the independent economic and financial expert appointed by the grand jury. And you have 10 minutes, Mrinal.
Thank you, Seok. I'm very grateful to all the panelists, SIAC and Chirag from MNLU, for coming on board for this exciting topic. We've had a wonderful debate, and I do understand that it is critical for the funders to evaluate the uncertainty aspect in calculating the realistic claim value based on loss of future profits. However, I'm not sure if it is reasonable for the funders to completely ignore the loss of future profits claim, as Dilip said. I mean, so before we analyze the uncertainty aspect, let us first understand and differentiate between wasted costs and loss of future profits as the two claims. So wasted costs, or hard losses as the funders define it, is the amount of money required to put the claimant in the same economic and financial position it would have been in had the contract never been made. So indeed, in this case, you're not required to make future projections, and there's generally less uncertainty inherent in the calculations. However, sometimes there can be a debate around wasted costs too. I mean, like, there could be costs allocation issues. How much of the investment amount really relates to the disputed project rather than other projects, as it is commonly seen in the real estate sector. The loss of future profits refers to the amount of money required to put the claimant in the same economic and financial position had the contract been fully performed. So in general, such losses are calculated as the difference between the counterfactual but for financial position and the actual financial position of the injured party over the relevant assessment period. What's important to know that both the but for and actual financial positions should fundamentally reflect a credible estimate of the projected future cash flows of the business, which is then discounted back to the date of valuation using an appropriate discount rate. And this is commonly called as the discounted cash flow, or the DCF method of valuation. It's pertinent to note that the two claims are alternate to each other. You can't claim both. It's one. It's either or. So perhaps you know, the issue which is emanating from Dilip's key points is the limitation in loss of profit analysis. It's sensitivity to the uncertain inputs. Now, in order to prepare a projection of a business's cash flows, it is absolutely necessary to make numerous explicit assumptions about the future of that business and the markets that it operates in. For example, it's necessary to form a view as to the rate at which the cash flows will grow in future during the explicit forecast period, and even beyond that period in perpetuity, which could be 5 years, could be 10 years after the date of assessment. So, and there are other examples like the impact of inflation or the impact of exchange rate on the future cash flows. So this uncertainty of inputs is actually compounded in case of early stage businesses where there's no track record of steady historical cash flows, which can be used to calibrate projections of future cash flows. But in my view, the fact that the loss of future profit analysis using DCF can give rise to a range of claim value based on the range of input assumptions does not undermine the case for seeking to undertake this analysis where the information allows. Rather, in my view, it demonstrates that the value of a business is sensitive to certain future events. The rejection of DCF methodology as such in calculating loss of future profits claim has largely been in the cases where the tribunal considered the results to be too uncertain or speculative, or when the subject of the valuation itself has no history of operating profitability. So coming back to the question, how do you address this uncertainty in calculating the loss of future profits so that funders are more confident in assessing the realistic claim value? Now, there are several factors which should generally be considered in building a robust, credible, and reliable set of projected future cash flows. It starts with the presence of contemporaneous documents, evidence, and parties agreed, the mutually agreed business plans. Second, general availability of recent budgets and forecasts about the business. Third, the assumptions that are considered in the business plan are reasonable, could be substantiated using certain evidences, documents, certain market reports. Fourth, there's a history of profitability, and there's general availability of historical financial information. Also, it's equally pertinent to consider the impact of macroeconomic factors, as discussed earlier, whether it's GDP growth rates, it's the inflation, it's the exchange rates. Then you take a step down in the top-down approach. You need to consider the impact of the industry, demand and supply factors, competition in the market. You also need to take into account the geography and regulatory environment in which the business operates. And of course, if there are any company-specific factors that need to be considered while assessing the loss of future profits. It's also generally preferable to triangulate the results of DCF analyses with those of other valuation methods or to other evidence of value than to completely ignore it altogether. But before I conclude, there's one more aspect. The current pandemic is actually likely to make this process even more challenging. And it may result in an extended period of volatility and uncertainty, especially in the global financial markets, which is actually going to result in disruption of future cash flows. Now, it may be difficult to quantify the duration of such period of uncertainty and the extent of the damage caused to businesses during such period in both the counterfactual but-for and the actual financial positions. In addition, the impact of the pandemic may vary across companies, across sectors and geography. Therefore, a possible solution is to have a rigorous cash flow analysis. And that is required, it's a must, to ensure that any uncertainty is appropriately reflected in the financial projections of subject business. You know, it may be relevant to develop multiple financial scenarios and business models to reasonably assess the likely impact of this disruption on future cash flows by accounting for all those relevant factors that I've discussed about. Thank you.
Thank you, Mrinal, for a very interesting and informative presentation. So now, the exciting moment. We are going to conduct a post-debate audience poll on the question, is India ready for third-party funding? Could we have the poll up again on the screen, please? The audience will get 30 seconds starting from now to vote. Right, time is up. Could we have the results, please? Wow, talk about close, well done. So Fereshte with 51% of the votes and Dilip, wow, 49%, got a cliffhanger. Very exciting, and thank you very much, both of you. It's now over to our grand jury to share their views. And interestingly, instead of ladies first, it's the gentlemen first. So Jain, over to you, please.
Thank you, Seok. I think it's good to be the only man on the jury. I get to speak first, and therefore I possibly won't let anyone else have a chance to speak much. But I think I must first thank Bhaskar for his views on the corporate side of the entire funding arrangement. I think they were very informative. And of course, our own dear Mrinal for having given us the quantum expert's view, and the jury is very grateful to you. But I think the day belongs to the two debaters, Fereshte and Dilip, who've given, I think, a stellar performance of their sides of the case at hand. Is India ready? In true Oxford style, the jury is in favor of Fereshte, so India is ready then. And Dilip, you must put in all your money now in India. And that's, I think, one of the compulsions of attending this debate. You must now bring in money and fund arbitrations and litigation in India. And I'll also make a compelling case as to why you must do it. Now, let me share some of my thoughts on this issue. If you ask me, is India ready? And that's the first question, of course. I think India has always been ready. India has been ready since 1872, since the Contract Act came into existence itself. We didn't borrow the principles of champity and maintenance in India. We kept them out. And Indian law, therefore, clearly recognized third-party funding as being as much part of our law as it is today. Let's take the earliest judgment in 1954, G, a senior advocate, who did a contingent fee and was almost struck off the bar. Contingent fees in that case, the Supreme Court held, and a large bench, a 5-judge bench of the Supreme Court held, that a funding arrangement of that kind would definitely be legally justified if it were not with a lawyer. That was the only factor there, and that's a finding which is conclusive. We fast forward to 2018, Bar Council of India versus Balaji, Supreme Court recognized it again. Therefore, India has always been ready for third-party funding. There is no question about it. But I want to tell you an interesting story now. This story started just pre-independence. And pre-independence India, in Hyderabad, one of the Nawabs of Hyderabad passed away without an issue. Once he passed away, there was a fight for his properties. And therefore, the Nizam of Hyderabad appointed a committee to go into this. And interestingly, one of the claimants came up and actually had a funder who funded that entire litigation. Now, the claimant, interestingly, succeeded, and the funder was therefore entitled to money. It was, I think, 1 anna per rupee, which was almost 1:5 ratio, and not 1:10 as our present third-party funders want, a 1:5 ratio, and that 1:5 ratio would work. But the fundee refused to pay. And therefore, the funder then went to court to recover this money, and that was a sum of 75,000 rupees, which was the fund. And with the benefits of the litigation, it would be about 3.5 lakhs. So with this money, they went through this entire litigation where the court held that the contract was proved, the money was due, but there was one clause in the contract which said that the funder would use all his influence with state and central ministers to try and ensure that the fundee would recover or get his share of the property. And that is where the court held that it was opposed to public policy. And this, I'm talking of pre-independence in 1949. And the matter reached the Supreme Court and was decided in the year 1991. So you can look at almost 40, 50 years of litigation. And the Supreme Court examined this, and it's actually a very interesting judgment on third-party funding, which no one speaks of. But this case, actually, the Supreme Court concluded, and before the Supreme Court, the issue is very simple. Supreme Court only considered the question. He said, there's no question of giving you the benefits of litigation. Leave was granted only to examine as to whether he could recover his 75,000 rupees. Supreme Court said, the term in the contract is in violation of public policy, and therefore violated of Section 23 of the Contract Act. And therefore, from the fundee's point of view, it was a great result. He got the money to fight the litigation. He kept the benefits of the litigation, didn't have to pay. And the Supreme Court held that the funder couldn't get a single rupee. Now, is that an argument against third-party funding? No, it isn't. And I'll tell you why I'm saying this. Though it took such a long time, our legislative framework has changed. And today, our framework is very different. If you look at the framework today, there are two important factors which have undergone change. The amendments to the Arbitration and Conciliation Act, that is the 2015 amendments, and the introduction of the Commercial Courts Act. These are two factors which everyone must bear in mind when they examine the question as to whether this whole fear of not recovering money is really a true fear. Arbitration today should be completed in 12 to 18 months. A challenge to an arbitral award will go to a court and there is no automatic stay. You must necessarily ask for stay. And if you ask for stay, you must deposit a certain amount of money, which could range from 50% to 100%. If that is the amount of money that is going to be paid or deposited, isn't that sufficient security for a third-party funder to say that I am now likely to receive my money? That is the first part. Let's look at the second thing, the Commercial Courts Act. We are worried in our country that courts take a really long time to decide. The first level of litigation takes 5 to 7 years. The second level takes 7 to 8 years. And at the end of it, you're looking at 25 years. But no, but if you look at the Commercial Courts Act, the Commercial Courts Act speeds up the entire process. You have, and you are required to give a judgment quickly. The provisions of the Civil Procedure Code have been altered. The provisions of the Evidence Act have been altered to make it easy to prove your case. Because they all accept that these are document-intensive litigation and not so much of litigation which requires oral evidence. And therefore, you are able to fast-track the entire process. And then the appeal is governed by the Civil Procedure Court, which requires you, the unsuccessful party, to deposit in court if you want to stay of the first order or the first judgment of a court. Now, that makes, in my opinion, a significant difference. A difference so significant that today India can never be said to stand back or fall back insofar as funding is concerned. Funders must examine this, the fact that there is no illegality attached to it, the fact that of money which is paid to fund the litigation can certainly be recovered. It is, of course, sometimes a matter of time, but there are legislative protection in place which ensures that you will recover your money. Having said that, the only concern that any funder has in India is as to delays, the law's delays. And as I said, there are going to be delays. Of course, India is a large country. India has a large amount of litigation, and it is not like England or Singapore where you file a case, you get a date, and the case is over. We have a large amount of litigation, but today the legislative framework ensures that that litigation will see the end soon. And commercial litigation in specific has been given a significant amount of legislative backing. And all of this is only with one view, to ensure speedy resolution of disputes. And to my mind, the only concern of a funder is time. And there can't be any other concern. Now, if time is addressed, I think Dilip must now consider bringing money into India. Thank you very much.
Thank you, Deanne. And now, Shireen, please. Shaneen.
Yeah, I was just wondering whether you meant me or Sherina.
Sorry, I meant Shaneen.
Hi, everyone. I reciprocate my other speakers' thanks and welcome. And I enjoyed the very impressive debate. I want to touch upon just 3 things, and I'm going to tell you what those are now. One is the issue of loss of profit, which Mrinal so eloquently pushed as an expert. The other is the issue of contingency fees. And the third is the regulatory aspect, which I think is what actually moved the vote a little bit in Dilip's favor, which I will address perhaps in a little more detail, but not with many more answers. So the point is that we've seen that loss of profit is a slightly more uphill battle to meet. And whether you are a claimant seeking loss of profit or you are a funder looking to fund a claim, you're looking for certainty. You're looking for time, efficiency, cost efficiency, effort efficiency. And therefore, I think what needs to be done really is a cost-benefit analysis or an effort-benefit analysis. If you find that your wasted cost approach and your loss of profit approach have a very small or narrow delta between the two, then perhaps you veer on the side of certainty and you go with wasted costs. If, on the other hand, you've front-loaded your case, you've had a fantastic expert like Mrinal on the table, and you find that you have a viable loss of profit claim, which is much higher, and it usually is, then I think it just makes sense to go for the loss of profit. And that is a conversation that is had between 4 stakeholders to the claim. Obviously, the client, the lawyer, the expert, and the funder. So it really depends on the facts of the case. The second thing I wanted to touch upon was contingency fees for lawyers. I know Bhaskar noted that and was quite gung-ho about contingency fees. And I'm with him. It's something I think that law firms are keen to push as well, as it is becoming more common the world over. Singapore and Hong Kong are probably going to be the newest entrants to that regime. But is it sufficient to have only a lawyer put skin in the game in terms of those contingency or success fees? While the lawyer's fees may be funded, you still have fees of the arbitral institution, you have your expert fees, counsel, arbitrators' fees. So I don't think that the lawyer's fees can take the place of a funder. Now, why would a lawyer fund? Not fund. Why would a lawyer have skin in the game? A common misconception has been that CFA agreements allows lawyers to pursue unmeritorious claims, but it's really similar to the approach that a funder would take. Why would I have skin in the game if I thought my claim was frivolous or unmeritorious? In fact, you're going to find CFAs only when the lawyer believes in your case. And when you're talking about issues of disclosure of funding or issues of disclosure of CFA agreements, it can be something that is psychologically detrimental to a respondent who sees that a funder and a lawyer have backed a claimant's case. So I think there are many pros to it. The Indian legal profession is really pushing for that because it puts us on a level playing field with a lot of our contemporaries. And I think it's an easy win for our government to do. So I'm quite hopeful that that is something that will come in quite soon. Of course, having said that, what are the kind of cases, what are the kind of claims where CFAs will be allowed? I think similar to the regulation around funding. And I believe that in India, it is not going to work without some formal regulation. I don't think self-regulation will work for us. And I say this for both contingency and for funding, what are the kinds of agreements that are allowed? What are the kinds of cases allowed? I saw in the chat that someone talked about class action. That I think is going to be a massive waterfall of litigation once someone dips their toe in the market. Under the Companies Act, the new amendments, new as in 2013, class actions are now allowed. So commercial claims, commercial arbitrations, damages claims, class actions, I think these are the kind of cases that are amenable to funding and are amenable to CFAs as well. Both Singapore and Hong Kong have allowed funding in international arbitration and international commercial cases. And I think that's a good place for India to start. And I think class action is also something that is very viable to both. I want to just touch now upon the regulatory issues. I am absolutely with Dhyan and with Fereshte that I see no bar on the legality of funding today. I do not see a court setting it aside on the grounds of champity or maintenance because clearly those are not applicable to India. I also do not see a court setting it aside on the basis of it being contrary to public policy per se, unless the agreement itself is something that is absolutely unconscionable and usurious. And in fact, that kind of an agreement will be set aside on the grounds of public policy, even in the UK, which is self-regulated. But I think the issues that India faces are more regulatory. And those are what Dilip alluded to. When you look at a typical funding agreement, which is non-recourse, where does it fit in? Is it a capital account transaction where it alters the assets or liabilities of a funder who may be resident outside India, or a funder who is resident in India but wants to repatriate funds? If it is a capital account transaction, RBI approval is required. But a non-recourse, a loan is recognized as a transaction. A non-recourse funding transaction is an unknown beast. It is not recognized in India. And for anyone who knows anything about the RBI, you can be almost certain that the RBI is not going to give approval to these kind of transactions. So it may work for a domestic fund that Dilip wants to set up in India and where he does not want to repatriate outside. But the moment you're looking at repatriation offshore, I think there are FEMA and RBI issues which are going to have to be regulated before this becomes a viable option. The other thought was setting up an alternative investment fund. But how is that structured? Even the AIF regulations require investment only in equity or equity-linked and debt securities. Claims, litigations are not investments as envisaged under the AIF regulations. Additionally, investment under an AIF fund is treated as FDI and there are sectoral caps. Would that mean that you would have to look at the underlying transaction for a claim to understand whether it fell within the sectoral cap or not? This is unclear. We don't have an answer. So for now, and possibly maybe for the next 1 or 2 years, or maybe even until regulation is in place, what I think we're going to see is funding of cases where recovery and payments can be made offshore. So Indian claimants against foreign respondents, where everything takes place offshore, or the purchasing outright of a claim or an award. And we've already seen that done in the HCC and Patel Engineering transactions. And the HCC transaction was a veritable cornucopia of awards of $600 million US. And the thought is to park these awards into a special SPV, and the funder will fund the SPV. Therefore, he is acquiring equity. And the minute you look at that structure, it is a form of third party or litigation funding, but it is not your stereotypical non-recourse agreement that we have in mind when we are talking about it. And the last issue on regulation is, of course, tax. And we all know that we've got very eager tax authorities, and Fereshte also alluded to every dollar being taxed. Well, this is going to be taxed hands down, and that is another issue. It is a cost that the funder will have to look at. Does he meet his 1 to 10 threshold, or is he willing to give a little bit to the government to get his feet wet in this jurisdiction? I think the next 1 or 2 years will tell. Thank you.
Thank you very much, Shanine. And now, Sherina, your views, and please wrap up the grand jury's views as well. Thank you.
Thanks, Sophie. Wow. What an invigorating debate. Congratulations to Fereshte, but also congratulations the other way, because I saw that we managed to move from 64% to 51% for the yeses and 34% to 49%. So congratulations to both of you, and a big round of applause. I very much enjoyed listening to the views from both sides of the coin. So succinctly put together, it gives a lot of food for thought, and particularly on a topic that is slowly but steadily becoming very much part and parcel of the disputes market. Third-party funding is here to stay. Mrinal, who's been the mastermind and meticulous organizer behind this whole debate, has given each of us strict instructions about topics that we should touch upon, and I've been asked to touch upon and give an international flavor. There's been quite a lot of discussion about regulations and regulated versus unregulated markets. So I'll look at a couple of countries. I also thought it might be practical. No one's talked about ADR, and you think, well, why would you talk about ADR when you're looking at third-party funding? So I thought I'd just talk about some practical experiences of third-party funding and its actual effects on mediation. And then finally about the effects on the enforcement of the award. So let's take the first topic, which is regulated versus unregulated markets. In general, it can be said that the regulation of third-party funding internationally has been pursued by one of the following routes. One is that some of the jurisdictions have adopted legislation and rules around third-party funding. Two, in some jurisdictions, it's being developed on an ad hoc basis by case law. And three, self-regulation, where in the absence of either legislative or judicial guidance, professional standards are being developed. So let's look at the UK first. At present, there is no legislation regulating third-party funding in the UK. The government has, however, said that it is ready to investigate matters further should the need arise. So in fact, in the UK, and I was looking at interesting statistics, there are more specialist litigation funding companies than in any other jurisdiction, although the size of the domestic market for potential funded litigation is undoubtedly greater in the US than in the UK. So very interesting. The rich diversity of funding companies based in London is reflected in the fact that England and Wales was the first and the only jurisdiction to have a code of conduct for litigation funding, authored and enforced by the ALF, which is the Association of Litigation Funders. Therefore, it would seem that for the moment, the UK has gone down the self-regulation route. Now, in order to be a member of the ALF, funders have to comply with a voluntary code of conduct for litigation funders, first published in November 2011. This was actually developed, interestingly, by the Ministry of Justice working groups on third-party funding, and it was set up by a response to a recommendation by a leading judge called Lord Justice Jackson. who gave a comprehensive review of civil litigation costs. The code contains a number of rules that funders have to abide by, but the ones I found interesting were not to attempt to influence the litigation, to pay all the debts when they become due and payable, and not to terminate a funding agreement without good reason. Breach of the code entails a fine or a termination of the member. Many funders are not members of the ALF at all. And so when I am looking for a funder, I actually do look to see whether the funder is a member of the ALF or not. Finally, litigation funders may be subject to regulation by other bodies. So for example, many funders consist of being solicitors, and they are therefore regulated by the SRA Code of Conduct, which is a Solicitors Regulatory Authority Code of Conduct. In addition, funders that are registered and based in the UK are regulated by the Financial Conduct Authority, although the actual funding arrangement is not. Enough about UK, and let's move to the US. It's similar to the UK. There is no legislation, and the US has adopted the second option, namely regulation on an ad hoc basis via case law. Litigation funding in the US is primarily governed by three areas of law. One, state common law and statutory limitations on providing financial assistance to litigants. Two, state statutes governing debtor-creditor arrangements. And three, attorney ethics rules. There are no rules specifically regulating third-party funding or requiring third-party funders to be disclosed to the court or the other side, although courts are becoming increasingly requiring this. Now let's move to Hong Kong and Singapore, and I know this has been touched upon. They both adopted legislation permitting third-party funding arrangements in the context of arbitration, and in 2019, Hong Kong actually produced and published a code of practice for third-party funding and arbitration. So what is international arbitration? What is the market doing? When you look at it, the international institutions and the professional organizations, they are beginning to address the involvement of third-party funders in international arbitration. So it's interesting to read actually the 2014 IBA guidelines on the conflicts of interest, specifically, which states that the parties should disclose any relationship, either direct or indirect, between the arbitrator and one of the parties. Now, why is that relevant? Well, it is because the concept of party is extended to relationships with persons or entities having a direct economic interest in the award to be rendered in arbitration, such as an entity providing funding for arbitration. So it's addressed in the 2014 IBA guidelines on conflict of interest. Now, whether we're in favor or against third-party funding, the industry is obviously increasingly requiring a clear, uniform, and a binding regulatory framework within the field of international arbitration. And I'll just throw another statistic out there, because in 2015, the Queen Mary School of International Arbitration, which is a formal school, did a survey where a clear majority of the practitioners, and it was about 71%, expressed a desire for regulating the industry. And approximately half of the respondents, which was about 49%, with practical experience in third-party funding, agreed with the findings. So let's move on to the topic of ADR and the issue relating to third-party funding and its effect on litigation. We've actually found a dynamic at the negotiation table that changes dramatically where there is a funder involved. Sometimes it's positive and sometimes it's being negative. So I was recently involved in an arbitration where we had absolutely no knowledge that the other side was being funded. We found this out when we asked the other side to exchange names of who would be present at the mediation, which was to take place in a few days. And the names came from the other side. It was the partner, it was the client, and it was a litigation funder. Wow, so we were shocked, and we said, okay, so the other side being funded. We had told our client that we didn't conflict. This was obviously reiterated when the other side actually revealed that, that they had a funder on board. How did the mediation go? Well, not very well, as the funder clearly did not want the matter to settle. He had skin in the game. So watching the dynamics when we were all at the negotiation room, it was actually quite blurred on the question of who was the client. Was it the actual client or actually was it the funder? Needless to say, the matter did not settle at mediation. It did actually settle after mediation, but it was only because of the efforts of the two lawyers on both sides. By way of another example, a partner in my team who was involved in a case that dragged on for 5 years found that the mere fact that the claimant had been able to secure funding in and of itself led dramatically to settlement. So he actually had 4 arbitration awards in hand that he was getting ready to enforce, and he was preparing another round of claims. Within a month, he said, of him confirming to the other side of the Chinese party that they had engaged funders, the other side agreed to a full and final settlement. So in this respect, funding is obviously a very powerful tool. There are several explanations for this. Funders will only take on cases that they consider to be good returns and therefore consider to have a strong likelihood of success. This is where it is important to bring in people like Mrinal and FTI to do a good, thorough quantum analysis. If a claimant obtains funding, it means the case has met the funder's very high threshold, and that's usually about 60%. Another reason for the dynamic changing is that traditionally a litigating party bears both the upside as well as the downside. So in other words, if they win, they receive; if they lose, they pay. However, third-party funding arrangements dramatically change this, because if a funded claimant loses, someone else will pay the cost. This changes the whole consideration of risk, and the claimant might feel that it has a free run at the case. I'll quickly touch upon the last topic because I know time is running out, which is enforcement with third-party funded awards. So when the third-party funder decides whether to fund or not, the funder is primarily looking at merits, the benefit cost analysis, which is the quantum, and obviously the enforceability. In fact, enforceability is probably the first thing that they will think about. An investor might decide actually not to fund the case, even if it has strong merits and a quantum, if it is linked to a state where the award or judgment might not be enforced. So, for example, it may be impossible to enforce awards in countries where funding is impermissible. Signatories to the New York Convention in relation to arbitration cannot refuse enforcement of arbitral awards, except on narrow grounds. And when I looked at the grounds, I would think the only relevant one really would be public policy. And it remains to be seen whether any of the countries engaging in skepticism towards third-party funding will develop any case law in this regard. It's therefore advisable to consider issues of enforcement at the time of obtaining funding. And I'm actually working with a funder at the moment where I'm doing the merits analysis for them, and we're looking at enforcement very, very, very carefully. What are the questions I'm asking? 1. Are the countries where the assets are located signatories to the New York Convention and are doing a sweep of the assets? What interim measures are available there? And do they have local laws restricting enforcement? So on the other hand, it has been pointed out, having funders may facilitate the process of enforcing against assets, which are actually difficult to locate. And funders, interestingly, sometimes have greater access to information and a greater availability of resources and more experience or expertise on finding assets. I believe my time is up. I have learned that it is actually better to leave your audience before your audience leaves you. And so I end in the same way I began, with the thought that third-party funding is here to stay, and ultimately our tomorrow needs new and different solutions today. Thank you.
Thank you, Sherina. Wow, that's been amazing. I was just sitting here actually, and I'm sure I'm not the only one. I'm sure many of us in the audience also feel the same, that I didn't want this to end. I truly didn't. It's been an absolutely riveting debate, presentations by everyone, from our excellent debaters, the grand jury members, Mrinal and Bhaskar, each and every one of you. Thank you so much. I've learned so much from all of all the points that you've made. I think it remains for me to thank MNLU again, Mrinal, for the excellent program and all the hard work, each and every one of you for all your hard work and your contributions. It's been a truly enjoyable, and I can't think of the last time I spent such a productive and enjoyable Saturday evening. I'm usually holed up, particularly these days, watching Netflix with my children. So this is a most refreshing change and a very enjoyable one. And I hope that there will be many more such opportunities to work together. So thank you all of you, and good evening.
Panelists can leave now. We'll be keeping stream like this for next few minutes to enable the attendees to submit the feedback form. Thank you so much.